A recent development in federal executive power has drawn attention from legal experts and political observers across the country. President Donald Trump has stated his intention to pardon Tina Peters, the former Mesa County, Colorado clerk who was convicted in state court on charges related to election equipment tampering. This situation has raised questions about the scope and limitations of presidential pardon authority under the U.S. Constitution. Background: Tina Peters served as the elected clerk and recorder for Mesa County, Colorado. In 2022, she was charged by state prosecutors with multiple offenses, including attempting to influence a public servant, conspiracy to commit criminal impersonation, and violation of duty. According to court documents, these charges stemmed from allegations that she allowed unauthorized access to voting equipment in her office. In October 2024, Peters was convicted in Colorado State Court and sentenced to 9 years in prison. Presidential pardons have been part of American governance since the founding of the Republic. Article 2, Section 2 of the Constitution grants the President the power to issue pardons and reprieves for offenses against the United States. This authority has been exercised by presidents throughout history for various federal crimes, ranging from individual cases to broader acts of clemency. Recent developments: President Trump has publicly expressed his intention to pardon Peters, describing her conviction as unjust. According to official statements from the White House, the president views this case as an example of what he characterizes as politically motivated prosecution. However, legal analysts have pointed out a significant obstacle. Peters was convicted in Colorado State Court, not federal court. Constitutional scholars note that the presidential pardon power, as currently understood, extends only to federal offenses. This interpretation is based on the text of the Constitution itself, which specifies pardons for offenses against the United States. State-level convictions fall under the jurisdiction of state governors, who hold pardon authority within their respective states. What officials and experts are saying: Colorado Governor Jared Polis holds the constitutional authority to grant clemency for state-level convictions in Colorado. According to public records, Peters would need to seek a pardon or commutation from the governor's office, not from the federal executive branch. Legal experts from various institutions have weighed in on this issue. Constitutional law professors note that the separation between federal and state criminal justice systems is a fundamental principle of American federalism. The Supreme Court has historically maintained this distinction in its rulings on executive clemency. White House officials have not yet clarified how they plan to proceed given these constitutional limitations. Some legal observers have suggested that the administration may